ट्रांसक्रिप्शन नंबर 101 स्टार्ट। मिस्टर डिप्टी चेयरमैन, there is no dispute in regard to the question that the working journalists had been suffering for long and that they need legal protection in their profession. As they were suffering, government appointed the press commission, and as a result of the recommendations of the press commission, we are here discussing this bill today to safeguard their interest. Now, our aim is to protect them from their employers. This bill gives them protection under the Industrial Disputes Act, as the operation for so many years of this act was in the hands of the Labor Department or the Labor Ministry. That department and that ministry are fully aware how it should be operated, as there have been lot of difficulties and lot of differences of opinion between one court in one state and that other court in the other state in regard to one item and one interpretation. The interpretation is required to be incorporated in this bill. As to what is meant by a workman, the Industrial Disputes Act has given the definition of the term workman, but it has been interpreted by different courts in different states in different ways. Now again, we are dealing with two parties, and one party is the employer. In the definition of the employer also, we do not find if we can properly put the directors or the managers as the employers. Now, this bill has tried to exclude certain staff and certain people doing certain jobs. So, the intention of this measure is to safeguard the interests of the working journalists by bringing them under the purview of the Industrial Disputes Act, by which they will be provided with certain machinery where they can go for the redress of their grievances. So, we must make sure that working journalists may not be defined as employers instead of as workmen. If, as we say here, an employer is one who is employed in a managerial or administrative capacity, there is bound to be difficulty. I will cite an example. Now, a working journalist might get two typists in his office, and he may have three peons. He may be actually a supervisor acting on behalf of the manager also. Now, he is performing two jobs. He himself is working, and he is also performing the work entrusted to him by the manager or the managing director. If such a person has got any grievance, he goes to this machinery that is to be appointed under this bill, and he is entitled to get relief. But as he is partially employed as manager, he may be denied that right. Therefore, I am afraid that whatever we may try to do, we must be very specific in this matter. I think we should say that the working journalist means a person. Those principal evocation is that of a journalist, etc. And then they are also termed as workmen under the Industrial Disputes Act. Otherwise, we will be faced with